So with that, we'll make a start. So hello, welcome to another one of these series of webinars that we've been doing with David in regard to the Renters' Rights Bill. Obviously, it's no longer a bill anymore; it's now an act. So this is one in a series we've been doing, and this with this actual one, we're going to hopefully have some understanding of the implementation, what's going to happen with the transition from a short hold tenancies at the moment to the new scheme of periodics. We've also got a load of questions that have been posted in advance. I've got quite a few there, and then at the end of this, we'll hopefully give some sort of background on our exemption, and yeah, then we'll go. We've got the chat running, so people can post some questions if they like, and we can try and answer these as they go along. I mean, bear in mind that we've got a limited amount of time, and there's already quite a few questions. So, but if David, I'm sure, can answer some of these, I'm sure he will try. So with that, let me just share our screen. And there we go. So first off, I'll just kick off with a little bit about us, really. So we're Sulets, so we're an ethically led students' lettings charity based in Leicester, which launched in 2012. We've got a connection with the two universities, and we rent somewhere in the region of about 2,300 beds per year via 7 halls of residence and 130-ish houses, something of that sort of size. So rated excellent on Trustpilot, Investors and People Platinum. Been running, as I say, for quite a long period of time now, and hopefully, if you're interested in your Leicester, you'll give us a look. With that, as I say, the agenda is this: so Renters' Rights Act implementation. So where we are, where we're moving to, a Q&A, and then a little bit about a specific exemption that we've got, which is quite interesting. I think certainly quite beneficial to us. So with that, I will hand over to David, and if you can tell us a little bit about implementation. Hello, David. How are you?
Hi, I'm fine, thank you. Great. So, yeah, I mean, the first thing to talk about, of course, is it's no longer the Renters' Rights Bill. It's the Renters' Rights Act 2025. It exists. It's real. So it got its royal assent on the 27th of October, which is Monday, I think, wasn't it? It feels like it was a Monday.
Yeah.
Uh, that means that some provisions will come into force automatically on the 27th of December. Now, they're not really provisions that will affect most people, but for example, local authorities have increased investigatory powers under the Act, and that comes into effect on the 27th of December. And in fact, the government has already published its guidance to local authorities on how to use those powers. But I, in all honesty, don't see this affecting anyone, because I can't imagine there'll be many local authority officers who on the 27th of December will start inspecting properties using their new powers. I assume they'll probably wait beyond Christmas and into the new year. And in practice, you tend to find anyway that it takes a few months at least for local authorities to fully assimilate their new powers and for them to fully understand them and work them through their own internal processes. So while these things are technically possible on 27th December, it may take some time. The other things that appear on 27th December is there are changes to long leases. So some long leases fall within the terms of the Housing Act 88 because their ground rents have gone up. They get bumped back out automatically on 27th December. And there's also a new set of powers that require local authorities to report to the Secretary of State on what they're doing and how they're enforcing landlord legislation. Those things all come into effect on 27th December as well, but I don't imagine they will, because the Secretary of State must then specify what the reporting periods are, and what information he wants, and I doubt he's going to be doing that over Christmas either. So the 27th December is a sort of date when things occur, but none of those things are, for practical purposes, going to affect many people. What the government has yet to announce, and is still talking about a little bit, is what date everything's going to come into effect. for real. And by when I say everything, what I really mean, of course, are getting rid of Section 21, getting rid of fixed term tenancies, getting rid of ASTs, all the new grounds of possession, um, and probably discrimination stuff, and the rent increase measures and those sort of things. I expect other things will happen later. Um, but the sort of core elements of the act that people have talked about most, and there's some degree of uncertainty. Tenant groups are asking for it before Christmas. So Generation Rent and Shelter were both suggesting that this should be done before Christmas. I don't think that's very realistic. Um, for all practical purposes, it just wouldn't be possible. One, I don't think the government's ready to do that. I don't think it's done everything that needs to happen before these things come into effect. I mean, for example, they're required to produce a leaflet, or they've said they intend to produce a leaflet that landlords will have to send to existing tenants. I don't think they've written that yet, or they haven't quite finished it. So I don't think that they are in a position to do this before Christmas. And in practice, I don't think the sector can cope with before Christmas either. Um, how much longer they give everyone is open to dispute. I think that they are likely in the end to plump for the 6th of April next year, which is the normal date and time that these things come into effect. It's traditional for legislation to come into effect in 6th of April and 6th of October next year. As it happens, coincidentally, the 6th of April also happens to be about 6 months from the day from royal assent. So it sort of works if it was the 6th of April for both the sector, which would like 6 months, and also uh, for the Secretary of State, who in practice can then turn around to tenant groups and say, well, we'll bring it into effect on a normal day when these things come into effect. And you can't really bring these things into effect over Christmas. Other things I think will be later in the year. So things like the PRS database is just nowhere near ready, and I don't think will be ready by the 6th of April. The government hasn't even finalised who the redress scheme is going to be, and they will then have work to do to prepare themselves. I can't see that being ready for the 6th of April. I would see those things being much more likely in October time next year. And then Awab's law, I think, will take even longer still. In social landlords, Awab's law has come into effect on December the 27th, but only for limited scope stuff, and is expected to be introduced over several years as it widens out. And I would expect a similar position on the private rented sector. I think the initial steps on Awab's law may occur in 2026, but I think it's going to take a while before the government rolls that out fully. And yeah, it may take as long as 10 years, as someone's just suggested in the chat.
Is this
I see someone's also just asked the chat when I think that the act will actually be in full on the legislation.gov website. I've got no idea, but I would quite like them to finalize it as well, because very annoyingly, the only versions you can see at the moment are versions with House of Lords amendments in them, which didn't actually pass. They were voted back down by Parliament, so you can't really see a finished version um, of the of the uh, of the of the act, and that's uh, still to be dealt with.
when we're saying about AWAB's law, is this with regard to the implementation of the dash standard as well that's going to apply?
No, so decent homes standard is a separate issue, and I think will probably appear later in October. That I think is pretty close to being finished.
Right.
And that's been going on in the background for some time, and there's been consultations on it. AWAB's law is the provision that says that landlords are under an obligation to inspect and deal with certain things and certain repair requests from tenants within a certain time period, and particularly damp and mold growth. But
Right.
the problem with AWAB's law to some extent is it's only enforceable by tenants themselves as part of a disrepair claim against landlords. So I don't actually think in practice it's going to change the terrain as much as people think it is.
Okay.
The more immediate issue for everybody will be the getting rid of fixed term tenancies and ASTs and things like that.
Sure. Okay. Okay then. So, I mean, is there anything that you can say with regard to you know, at the moment, I mean, we're obviously talking to a lot of people from the student sector. So you will be having a lot of agencies right now that will be writing tenancies for next year. I mean, obviously that's going to change as well, isn't it? Once the Act's implemented, if you want to benefit from Ground 4A, it's going to be no greater than 6 months, I think. But you will have people writing tenancies right now. These are going to be affected by this new law, obviously.
Hmm.
Is there anything you can make comment about the likely sort of transition period? Not so much the time, but how this will happen. So if you're writing, they're probably going to be writing, I'm assuming, still fixed term tenancies, although you wouldn't probably be a good idea not to. But is there any comment you can make with regard to that sort of transition over from one tenancy regime to another?
Yeah, quite a lot of the transitional provisions are actually in the legislation in Schedule 6 of the Act. And they've been there all along. It's just that people haven't got spent a lot of time looking at them until it got closer to being a real thing. Now, anything I say about this is caveated because the government can change the transitional regime as much as it wants in regulations, and I'm sure it will tweak it. And in any event, the transitional regime in the Act simply doesn't cover everything, and there will be other transitional material in regulations. But important things to bear in mind. I've mentioned the government having to produce a leaflet. So there is a power in the transitional regulations, which I understand the government will take up for the government to produce a leaflet, which all landlords will have to send to tenants within a month of this all coming into effect, which basically tells tenants that the changes in their rights. And so the upside of this is you don't have to re-paper existing tenancies. Existing tenancy agreements stay as they are, but you must send the government's leaflet within a month. And you will then that will then tell them which bits of the current tenancy agreement to disregard. But obviously, that means that landlords need to, one, make sure they have contact details for everybody, and two, they should be making sure that they've got an agreement somewhere in there that they can do these things uh, by email.
Yeah,
Um, so the second thing to bear in mind is it relates to Ground 4A, which you've sort of alluded to. There are some transitional issues with that. The first point is that the 6 month time limit doesn't apply for transition.
no,
So the fact that you've signed a tenancy now that's starting in more than 6 months would be a problem for Ground 4A normally, but it um it 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 won't be something that will affect through the transition. So if you've signed an agreement today that that is signed earlier than 6 months, it won't matter and it won't prevent you using Ground 4A. The second thing you need to bear in mind is that Ground 4A requires notice to be given to tenants before the start of the tenancy that you might use Ground 4A.
yeah,
Um, Now, the point to note there is that obviously you can't do that with a tenancy that's already started before Ground 4A existed. So the transitional provisions say that if you are going to rely on Ground 4A, you have a month after this all comes into effect to notify tenants that you will potentially rely on Ground 4A. So all landlords have one important thing to do within a month after this comes into effect, which is send the government leaflet to all their tenants. Student landlords have two things to do. They need to send the government leaflet to all their tenants, and they must also send a notice to all of their tenants stating that they intend to rely on Ground 4A. So those are two, and if they don't do that, they won't be able to rely on Ground 4A. Now, where it becomes a bit problematic is Ground 4A is actually a 4 month notice period. And if I casually say that this is going to come into effect at the beginning of April, that's less than 4 months from the date that most student landlords will probably be expecting their properties back,
right.
because they'll probably be expecting them back at the end of June or July uh, to prepare for relets in August or September. So one of the side problems with all of this is that actually, in practice, you probably won't be able to use Ground 4A anyway, initially, because the notice period won't work out,
Right.
and that's a bit of a pain in the whole structure.
So what would they do in that circumstance then?
Well, and a lot of people keep going on about this, but to be honest with you, I don't actually see Ground 4A as a big deal because the difference is no different from now. The fact of the matter is that if students don't leave now, then I mean, how many student landlords actually serve a Section 21 for the end of a student tenancy? Very few. Most students leave. If they don't leave, you would have to serve Section 21 notices and then go to court. Um, so in practice, the vast majority of students leave. Student landlords rely on the fact that students leave. And while people have got very excited about ground 4A, I think in practice it's not that big a deal. The thing that is a big deal, in my view, is students leaving early.
Yeah, yeah, I would agree. Although we do issue Section 21s, and we're speaking on a personal basis now, we do issue Section 21s. I don't think we've ever once used anything. We've never used them. They're in
And
the
in
sense
practice,
of
I
following
would
through.
presume if you had to use them, it'd be a nightmare because it takes about 5, 6 months to get possession. So,
Exactly.
it's almost academic. Okay, you issue it or you don't, but so what?
Yeah, yeah, I
And
agree.
ground 4A, I think, is the same. Yes, okay, I'm sure people will use ground 4A notices. If for no other reason, of course, then there won't be a fixed term in the tenancy and it gives a break point
Mm,
and makes it clear what you're expecting. Because the tenancy can't have a fixed term when you're saying to the students we want it back, and you can't say to them, well, we want it back on this date anyway, because that would be trying to grant a fixed term and is an offence. So in practice, people will use ground 4A notices if for no other reason than to tell student tenants when they expect their property back. But even if the students don't leave, then the challenge of actually securing possession will be pretty huge.
Obviously, the problem with the ground 4A thing, as we alluded earlier on, is you can't do it earlier than 6 months, which is going to cause problems, I would have thought, for landlords and lettings agencies, because it'll certainly compress the period of time when they can start renting, which is going to be more like January, realistically, if you're going to use that. But I'm sure we can come to that in the questions. So with that, then, thanks for that. If we maybe roll on to some of the questions now, then. So yeah, we've had an awful lot. I've selected as many as I could because this is, as I say, there's a limit of time, and this is one from RA, as a chap I know for many years. So, what are the transition period rules? I.e., what would be effective from the day it becomes law? Same for PBSA. Do they have a period when they can register for the ANAC code?
Okay, well, I'll answer this backwards. You can register for the ANAC code anytime you like. The government hasn't yet clarified what things will be PBSA exempt exactly because it's got to be in regulations. I would anticipate anybody who has got a space of more than 15 rooms, which will allow them to register for ANAC or Unipol, so a property with 15 rooms or more, is likely to be able to avail themselves of the exemption, depending on how the government chooses to word the relevant regulations. But the way the legislation is worded, it implies that if you've got rooms of spaces of more than 15 rooms, you'll be able to apply. Obviously, there'll be a wider group of people who apply for the ANAC. There'll be one group who are applying for Unipol and one group of people who apply for ANAC, and obviously educational institutions will apply for ANAC. And then it looks as though the existing exemption status, which you've already alluded to, which is set out in existing regulations, will also continue to apply. So there's going to be several different exemption regimes, which people are calling the PBSA exemption regime, but it's not really PBSA because it's got nothing to do with the PB aspect of it at all. Some of the stuff's not purpose-built, but it's designated student accommodation. So you can apply now, and as I understand it, the number of applications to Unipol has risen markedly.
Yeah, you'd imagine.
So and I'm sure ANAC is exactly the same. So I feel if you're thinking that you might be able to rely on this, I would advise you to get on with it and apply.
I think it's actually
Not
the other
not
way.
least.
Yeah,
Go on,
sorry.
sorry.
No, I was just
Well,
going
I
to say,
mean,
I
not,
think it's actually the other way around. ANAC is for the private sector.
sorry, I always get them mixed up.
It's UUK is the university's UK one, isn't it?
That's it. Yeah. So UK and the number of applications have gone up dramatically
Yeah,
already, and I would advise people to apply if they're thinking that they might be able to rely on that ability. I mean that would be an important thing for people to do.
yeah. I don't know if there's anybody on here from Unipol, but it'd be interesting if they're putting if they put in the chat the sort of growth that they've seen. But I suspect it is pretty significant, really. So nice.
Part of the reason I think people should get on with it is that obviously it's more than just applying. There's a whole code of practice you have
Yeah,
to
of
comply
course.
with and a whole load of things you have to do. And obviously people will need to make sure they have the processes in place in order to do this.
Yeah, yeah, of course. Okay, so rolling on.
And well, I'll go back to just the other part of that
Okay.
question. So the first part of that question, sorry, was the transition period, which I think I've sort of answered. I mean, the legislation is effective already. um, then uh, people can apply sorry, the legislation is effective already, but it's not effective in a way that is meaningful to you. So the legislation is enforced now, but it's only enforced for the government to make regulations under it. Everything else, we're awaiting announcements from the government, but it won't be. I don't think it'll be before Christmas.
No.
Just on the ANAC point, someone's just asked, Karen just asked in the question Q&A, which I thought I'll just quickly answer along the way. Can a student specialist agency apply for ANAC if houses are under 15 rooms? No. The ANAC and Unipol codes both have a specification in them that was forced on them by a previous Conservative government that says the code that you can only apply for the code if the property has more than 15 rooms in it. So you can't stick several properties together and say it gets more than 15 rooms, and you can't apply if the property is less. But I think this is one of the areas I think is quite interesting. There are some smaller developers now and small landlords developing spaces with sort of 17, 18, 19, 20 rooms, and some of those people will potentially qualify under the various codes and may potentially be able to rely on these exemptions if they apply for the codes. And I could certainly see some agencies looking to specialize in basically because there is a system in place whereby an agency can join the code on behalf of the landlord. And I can see some agencies potentially looking to specialize in dealing with those landlords who have got one 16 or 17 bed property that may well fall within the scope of the code, and that's certainly a possibility that I can see happening going forward.
Yeah, Nicola Brown, who's I know Nicola works at Unipol, has just said, yes, we've seen a rise in applications, national code by Unipol. Not my area, but the team has reported a rise in interest in applications, which, as I say,
yeah, and I think that was inevitable in practice, and obviously, it's going to put substantial pressure on Unipol. So, but both to process those and obviously to manage them going forward.
yeah, nice problem to have, though. I think probably. So
I'm sure, yeah, it's good to be popular.
yeah, right. Okay, so rolling on, we've got. I think this is more like an observation, really, rather than a question. Currently, I have 5 of our properties that we rent out to student groups as 12-month ASTs. We concerned new laws will force us to leave this market with the introduction of periodic tenancies. So,
Well, it's a good comment. Let's talk about this. I mean, the thing I think that is a problem clearly for landlords is the issue of students leaving early. Now, what I think is quite interesting about this is it does depend on your university,
right.
because dropout rates are not equal across all universities. So dropout rates, for example, at classic Red Bricks and Oxbridge are much lower because people really want to be there.
Yeah.
Dropout rates at universities that at post 92 institutions tend to be higher. Dropout rates at other types of university tend to be at the top of the tree. So there are different dropout rates at different universities. So I think that actually will impact on landlords' business models. So you may actually be better off to simply move your properties to a different location. So that's one possibility. The next thing that I think is interesting about this is how many students actually drop out during the course of a year. So there's quite a lot of dropout at the end of a year. Dropout rates during the course of a year, again, tend to be very variable between institutions. Some institutions don't get much dropout in year, but get quite a lot of dropout over the summer holiday. Some institutions have quite high dropout rates during the year. The next thing to consider, of course, is what's your scope for refilling your property and what's the available market. So in some areas, again, if you're renting student properties in Oxford, for example, and it drops out of the student market because the students leave, it's not like you haven't got other people you can rent to.
No.
If you're renting in Durham into the student market, those options may not be available to the same degree. So some areas are very much town and gown, and there simply isn't much call for the amount of rental property outside the student market. Some areas you can probably flex back and forth between the different markets, and okay, if the students leave, you won't return as much money, but you will still be able to rent it.
I mean, I think one of the other issues is it's not just the dropout; it's just people leaving earlier than the landlord would wish. So, typically a lot of tenancies are 48, 51, even 52 weeks, full year stuff.
Yeah.
You know,
But
the
I think
student,
again,
student doesn't want that, and I would guess that you're going to get a lot of people that are going to be giving notice potentially in March or April for 2 months further on, and
yeah,
then
strategies you can do to get around that. So what you can do, for example, instead of your tenancy starting in say September time or August time and finishing in sort of May, June time, you could start them earlier. So landlords could potentially look to start tenancies at the beginning of July, and effectively have the students there over the summer, knowing they're not in fact going to be there, and then running through. So there's less practical benefit in the students giving notice. The other thing, again, where I think it's interesting because it relates to your particular institution, is how much stuff is going on. You know, do people leave early, or is there enough going on around there? So again, one of the things that's really notable in Oxbridge, obviously, is that the students tend to stay on site much longer after their exams because there's lots of summer balls and things that are very prestigious and people want to go to. If your university though is very much people are there to do their exams and then they'll leave, then that's more of an issue. So again, it depends on the institution that you're renting into, and it depends on the area and how the institution operates, and and how much pool there is holding students in place, or whether the position is I'm doing my exams and I'm out of here.
yeah. You know, or if you're rented to sort of medical students that are going to be there, all, you know, basically the entire year, and much less likely.
Yeah. So if you're in on specific courses like vet students or medical students, or if you're renting to postgraduate students, for example, master students who'll be staying there to research dissertations, or PhD students who, frankly, having been one myself, that's being there over the summer is when you actually do your actual work. Because the rest of the time you've got teaching obligations and all kinds of things that drag you away from doing what you're supposed to be doing. Um, there are lots of things that will vary um, the situation.
I think for Beth, probably the best solution for her is probably to bring the tenancy forward, which you alluded to there. I think so, so that there's less chance that they will drop out within a period of time that you still want them to be there. You know,
I just want to be very clear what this issue is, because someone's just asked a question that makes clear that some people don't understand the issue. The problem here with all of this is if you have a tenancy that's open-ended and periodic, that means that a single student tenant can give notice that is binding on all of them. So unlike the current situation where it's a fixed term, and if one individual wants to leave, you would just say, well, you can't, or it's up to you to find a replacement. Under this new regime, one tenant can just give 2 months' notice and leave, and you will then either have to come to an arrangement with other people in the property, or suck it up.
okay, right, we'll roll on because we've got quite a few questions. So, Anna Coles, what concessions are there towards the student let market timings? Most students search for the next year's rental in November, tenancy agreements, deposits, notice periods. I'm not too sure.
What concessions? There aren't any.
No,
The only concession that was made to the student let market was that ground 4A was introduced. So there is a ground for possession for larger student properties, because they have to be HMOs as well. So they must have 3 or more occupiers.
yeah,
Um, that allows you to give notice that you want the property back to let to other students. And that's the only concession that was made to the student let market. There are no other concessions. In fact, I'm not even convinced that I would call that a concession.
no. That's a brutal answer, isn't it? Really, to be fair. Sorry, Anna,
Yeah,
but yeah, no, it is
there
what
are,
it
there are
is.
zero concessions.
Yeah, yeah.
And for some people, certainly, I'm aware of some people looking to let in alternate ways where they have the right kind of market and the right kind of property.
Right, okay. We'll roll on then. Scott, will this two-tiered system force traditional HMO student landlords to let from June every year? How will the student HMO landlords mitigate potentially huge voids? Or we're just sort of discussing that then, weren't we, really, with the idea?
Well, but, and then there's some good points here, because Steve has also asked a question that relates to this about ground 4A and joint and several agreements. So I think one way that student HMO landlords will mitigate it is they'll simply stop renting properties on a joint and several basis and move to individual room lets.
Right.
I think the way ground 4A is worded, it probably still is usable, even if you've gone to room lets, because the whole property will still be an HMO. But obviously, that's something that potentially the courts might end up considering at some point. Um, but this moving it to roomlets, I think will will help, because obviously then if you have dropout, it'll only be on a room, and then it'll be at the landlord's discretion who occupies that room. So actually, in some ways, that works better for students too. I think some other landlords might try creative strategies. One I've put out there is that rather than, for example, getting the parents to be guarantors of student tenants, you simply make the parents the tenants, which of course would stop the property falling within the scope of the Housing Act 88 altogether and would allow you to have a fixed term tenancy. But obviously, that has to be something you sell to parents, and it may be harder to persuade them to go down that road unless everyone's doing it.
Yeah, sort of tough call.
Um, yeah. Other people, yeah, will start tenancies earlier, and I suspect some people will simply leave the student market
Yeah,
for sure. And again, this is where I think the government has failed to properly appreciate the problem. And I noticed I was talking in the University of Kent and at Canterbury, and I noticed they were telling me how the university there has actually altered its term dates to more closely align with exams to reduce the incentive for students to leave early at the end of term. Because they're really worried about loss of student landlords, because they really need those landlords, because they can't accommodate all their students any other way. There's not many other opportunities. But in some areas, I think landlords will probably leave the student market and rent into other markets
yeah,
where that's available to them. And some, as I've suggested, might consider a different university altogether.
yeah, yeah. Certainly, where there's cities or more likely towns where there's a significant undersupply, you know, I would imagine there's still landlords and agents are still in a fairly sort of strong position. It would be my guess. But right, okay, so we roll
Well,
up.
but yeah, I think you make a good point as well. I mean, the other thing to bear in mind, of course, is the other thing, of course, that will happen is rents will rise. And it's already been suggested that rents will rise, and the reason rents will rise is because there's more students out there desperate to rent accommodation. There is landlord accommodation to rent.
Yeah, yeah. Very city by city based, I would have thought that would be. So, on the basis of rents, nice little segue there. How can we set rent levels when we don't know the term or voids, Hugh Bailey?
Well, I mean, rent levels are set based on a monthly period, and I don't think it will change considerably. I think what will have to happen is you'll have to look at how many people you've tried to have leave early in the past and make a guesstimate. I mean, that is the reality, and I suspect it's something that you'll need to keep an eye on and start and think about on a year-to-year basis. But
Yeah,
I
yeah.
mean,
So I
the
think you'll
short
find out
answer
at the end
is
of the
you'll
year when
probably
you go
start
in.
with where you are,
Yeah, I
plus a
think.
bit, plus a bit.
Yeah, I think that's one of the things that will happen. People will start factoring in. I think they're going to be here for X number of weeks on the basis of the sort of like, you know, the university you're at. But you'll only see that looking backwards rather than forward, I would have guessed. Yeah. Okay, so Belinda, are there any circumstances where previously converted building may qualify as purpose built and therefore have the same rules exemptions as PBSA?
Well, yeah, this is what I'm talking about, is that PBSA has been used and bandied around a lot, but that's not what the exemption actually says. The exemption is yet to be written. It's up to the government, but it looks to me like, and this was part of the problem, is the government started casually talking about PBSA exemption and seemed to suggest they could rely on the existing exemption with some reworded regulations. And they eventually realized that actually it's not that simple, and the PBSA exemption is doesn't work because most purpose-built student accommodation is not in fact purpose-built.
Yeah,
Um, so it's not a PBSA exemption. It's an exemption that relates to certain types of people, and in practice, I think it's going to end up dropping into a position that says either you're on a list, and that's probably the existing list, or alternatively, you're in the code, or one of the two approved codes.
okay, rolling on again. What is the impact on university accommodation? Should be none, shouldn't it?
Well, it depends what you mean by university accommodation, but I'm assuming what you mean by that is accommodation that is provided by a university itself from its own halls. And as you already say, the answer is there is no impact. I mean, in part, universities often weren't renting their accommodation on a tenanted basis anyway. Quite a lot of them are renting it as licenses, so it falls outside the Housing Act 88 and always has done. Where people have been moving towards ASTs, and many universities have, because it's seen as fairer and better quality to do it that way. Then they're already almost all listed on the magical exemption list, and I anticipate that they will remain listed on the magical exemption list. And then non-university providers, so the Unites of this world and people like that, are signed up to the various codes.
Where this would be impacted, I would guess, would be so certainly their own accommodation. Yeah, that they've got the pass, haven't they? They've got the magical pass. But if you are, say, advertising, you've got a scheme where you're advertising accommodation that's not your own, or you haven't got a lease on, or something like that. So I don't know, you've got a university accommodation department, and they advertise a load of external HMOs. They allow landlords to advertise them. They'll still be affected, won't they? There's no get out of jail for them, really.
Yeah, and I think the issue here is not university's own accommodation. It's the sort of private-ish sector, and some of that sector is totally private and has nothing to do with the university. But quite a lot of private sector student accommodation is quite connected with the university, either because they list via university organized and run accommodation listing services, or because it's large scale accommodation that's on contract with the university, and the university effectively puts people into it. And even my niece has just started at King's, and she's staying in a piece of accommodation that was provided, and she went through a King's organized application service and accommodation service, but the accommodation isn't provided by King's; it's provided by Unite, I think, but or
Yeah.
some other private entity, but have contracted with King's. But King's haven't provided it, and if it's being let on a tenant basis, then obviously the people who are providing it will have to be signed up to an appropriate code.
What I mean is in the situation where they allow like a HMO landlord to put or an agent to put accommodation on, have a link off their site or something like that. And but that's not going to be protected, is it? So that's not going to be covered by the PBSA exempt or the annex code exemption or anything like that. They're just essentially advertising on their site. So they'll have a site that will say, HMOs or something like that. Landlords can maybe put it on the site for, a nominal sum of money. That they're not going to be protected in that situation, are they?
Yeah, I mean that's going to be very problematic.
Yeah, yeah. Okay, hope that helps, Elizabeth. What's the status on giving notice to tenants in two-bed lets, please? Otherwise, students may overstay and complicate the arrangements for incoming students. That's going to be tricky, isn't it?
There is no status. You can't do it. So ground 4A applies to HMOs. And one of the things that has been brought up numerous times, and there were several attempts to amend the legislation, was students in 1 and 2 bed HMOs, that the government said that they were trying to protect those students because they were more likely to be families. And so they weren't prepared to compromise. I mean, to be fair, this actually is something the NUS pushed very hard for, and so in practice you could say that students have got exactly what they wanted. I fear that they haven't in fact got exactly what they wanted, and that there are considerable areas I'm aware where there are 1 and 2 bed student accommodation is a big part of it.
Yeah, yeah. So unless you're 1 and 2
Fall
bed,
within the scope of ground 4A, and landlords will either have to rent it elsewhere, not rent to students, which I'm sure some will do, or they will have to take the risk and rely on those people leaving, and they will not be able to sign up people so early. I suspect the reality is more of that accommodation does tend to be rented to postgraduate sector students, and so it's more likely that it will fall in a more conventional letting structure where you're not trying to run it on such a specific set of timelines.
but
It'd be more
essentially
open.
no specific protection for 1 or 2 beds.
Not from well, there is for students, but not from a landlord's perspective. There is no ground 4A. There is no way around that. There is no other notice.
Yeah.
You will have to. I suppose the short answer is you will have to deal with that as it happens.
Yeah. Okay. Show many more. We've got under the new Renters Reform Act or Rights Act, rather, landlords can't unreasonably refuse tenants with pets in an HMO with shared kitchen and bathrooms. Where tenants have individual tenancies, can landlords still refuse pets on the grounds that they will affect other tenants? Anthony,
I mean, the first point I would make here is the problem here is that people just keep saying pets as though it's a single thing, and of course, what all people really mean in this situation is cats and dogs.
yeah,
But it's more subtle than that. Um, if if I'm in an HMO and I want to keep a goldfish, then simply saying we have a no pets policy is not going to be reasonable because having a goldfish does not really impact on anybody else in the property. If I want to keep a Great Dane in my HMO, then quite obviously, or indeed, I should point out that it means pets. So if I want to keep my pet llama in my HMO, which is what I'm planning to do, I'm going to move into an HMO and get a pet llama immediately. If I want to keep a pet llama, then clearly that's going to impact on other people negatively. And yes, I think it's perfectly reasonable to say no. So the problem with the pets thing has always been that people say pets, but what they mean are cats and dogs. Um, but they're too generic about it. So
we did have somebody once that wanted to keep pet rats, and let me tell you, pet rats reproduce pretty quickly, is what I can tell you. So yeah, we definitely had somebody who did that.
yeah, and it will depend on the pet and the nature of the situation. But yes, I think in most cases, landlords will be perfectly justified and perfectly reasonable in saying no to pets in
Okay,
HMOs for sure,
hope
because
that
they obviously impact on other people.
hope that helps, Anthony. Nicholas, when the Renters Reform Act removes advance rent, can landlords ask existing international tenants without guarantors to provide one? If they refuse, are there any lawful options to manage the risk?
Um, yes, I mean the government's apparent solution for rent and advances guarantors and indeed professional guarantor services. I mean, there is some question about professional guarantor services and whether they work under the legislation. I think they probably do, but I imagine the courts might get involved at some point. Um, yes, you can ask for a guarantor. Yes, for sure.
Yeah.
And I think that will be your only option in practice, or you're just going to have to take the risk. If they refuse, are there lawful options to manage the risk? Well, not really, no.
So you're looking for professional guarantor services. Well, I mean, there's quite a few out there, but Housing Hand, Rent Guarantor, they're
Yeah,
some
and
of the
there are
big
new
ones.
rent guarantee schemes that people will look at, but I think the government's just made a terrible mistake here, and I don't think it's thought sensibly at all about foreign students, and I think it's a very bizarre decision, to be honest with you, because foreign students are just a huge boost to the economy,
Yeah.
and universities, many universities have been positively encouraged to attract foreign students and arguably gone overboard in some cases on doing so. And for the government to now make it really difficult by the back door, I think is crazy. I suspect that what will actually happen in practice is that many of those foreign students will end up falling into parts of the sector where there are exemptions available, where people can ask for rent in advance,
Sure.
or where they're larger institutions that don't feel the risks so strongly. But that's quite problematic in itself. The demographic of students from overseas is changing, and the number of Chinese students is starting to tail off slightly. They tended to go for these larger, more expensive pieces of accommodation. There's an increasing demographic of Indian students who want more budget HMO type accommodation, and that may just not be available to them.
I mean, interestingly, in PBSA, there's an awful lot of the big PBSA operators that will accept international guarantors. So, in other words, a
Yeah.
guarantor from outside the country. But you can imagine, obviously, there's quite considerable risk with that. But I suspect they've just got the balance sheet and the size of operation to be able to to be able to operate those sort of things. Whereas an individual landlord would be altogether more.
Yeah, so it depends where you're talking about. I mean, if you're talking about Scotland or the Irish Republic, then fair enough. I don't think it's very complicated. France is actually a bit of a hassle. Most European countries are a bit of a hassle. You go beyond that, it becomes just a bit of a nightmare to get money back, to be honest with
Yeah.
you. Um, so it depends a little bit by what you mean by international students. And again, this is where I think different institutions are very different because specific institutions, for example, have targeted specific countries. And it may well be the case that where there is an arrangement that aims strongly at a specific country, that a solution will present itself whereby someone in that country might offer some kind of and a company or entity might spring up that will offer a guarantee, and then will pursue people themselves within that specific country because they have local capacity.
Okay. Right. Rolling on again. Richard Eaton, if a typical high street lettings agency will not qualify for a special exemption from the RRB and will not be able to pass on the benefits to their landlord clients, do you think such lettings agencies are likely to leave the student HMO lettings market? Well,
I suppose it's possible, but the reality is there's quite a lot of money to be made in the student HMO lettings market.
yeah.
Um, and a lot of that is actually made on domestic students. So I think that would be a premature decision to make, not to put too fine a point in it.
I mean, look,
Um,
this is something obviously that we directly do. So I think that some of the bigger operators, and there's some big operators that have got sort of quite national exposure, and I suspect that they will be able to weather any problems, and we'll actually see, as with all things in life, whenever there's a massive change, there's some people that will do well out of it and some people that won't. And I suspect that some of the bigger operators may gobble up some of the smaller ones, maybe, and see it as a buying opportunity. I can see that happening. I can see some of the smaller ones, or more likely the ones that do this as a bit of a side hustle almost. So they're a regular residential lettings agency and they do a bit of student stuff. I think they might find that it becomes too problematic to deal with the student stuff. So I can imagine that happening quite a bit more. I've already seen some of these lettings agencies start to sell up of all types, but who knows? I know it's a question to ask in another year, 18 months, isn't it, really, I guess? So who can say for certain? Hope that helps, Richard. Grant, hi, I think we're coming to the end of these. Hi, if a third year student resides in a one bedroom flat in PBSA that isn't a member of a code, then how would the landlord remain compliant if they give the tenant notice but are therefore in breach of planning? I'm not too sure I understand all of that, really. Something you can say on that, David?
Well, there is a ground for possession for planning breaches. There's a ground 6B for planning breaches. So there is another way to obtain possession if you're at risk of a planning breach. So yeah, it's fixable.
Okay.
I don't really want to get into a long discussion of the very large number of grounds for possession, the 37 grounds for possession that now exist.
Okay. No, hold on, let's just have a look and see. Right, okay, so we've got a couple more left. As we understand it, the existing fixed term tenancies will remain fixed. No, they won't. Is there any indication that if at the end of the fixed term the landlord wishes to serve notice, they will be able to do so under Section 21?
Well, so yes, as you've already indicated, you don't understand it. Because existing fixed terms won't remain fixed. All existing tenancies convert automatically on R day or D day, whatever you want to call it, to periodic assured tenancies. And so no, you won't be able to serve Section 21 at the end of the fixed term. Section 21s that are served before the conversion date will remain valid for 3 months after conversion date. But obviously that's really there to deal with tenancies that come to an end pretty much at that point.
Yeah.
But no, you can't do that.
Okay, final question then. It might be worthwhile looking at the chat after that. Matt, will current student tenancy agreements be affected, or will they likely run their course by the time the new act is rolled out? I suspect this means what he means is a timing issue, doesn't it, really? That's what Matt's saying there.
Well, I can't say for sure because I don't know for sure what the date is. I think it'll be April, in which case, yes, current tenancies will be affected. And of course, the tenancies you're signing and writing now will definitely be affected. And obviously, there's a complex scenario here that people are writing tenancies that won't come into effect. Well, I mean, they're in effect because they're signed, but the people won't occupy until after the legislation has changed them. So you're writing tenancies that that will be changed by the time they become useful. But those tenancies have to be written as they are now, and they will convert at an appropriate point into a new style tenancy.
Okay. Well, that's the end of those. We've got a couple in the chat that that are quite interesting. Ian Lapsley said, "Can a landlord accept rent in advance if the student wants to pay each of the 3 times in order to coincide with their student loans?"
Sorry, I lost you there. I don't know if it's me or my connection or.
Sorry, bottom of the webinar chat, one up from the bottom, Ian Lapsley. Can a landlord accept rent? It's just moved. Can a
Okay,
landlord?
yeah.
Yeah,
Rent in advance is quite interesting. So let's talk about that in a bit more detail. You can't accept rent in advance for the first month. They can only pay a month. If they pay you more, you have to give it back. If you accept it, it's an offence. And you can't ask for it either. If the tenant wants to pay after the first month, the tenant wants to pay a sum in advance, then they are free to do so and you can accept it, but you can't ask for it and you can't press it. And you can't force people to do it. So there is an option available, but it's genuinely optional. And I think one of the things that's really strange or difficult about this is that is that is that I think tenants may make promises or suggest it, but I don't think it's going to happen.
yeah. Okay. Okay, I think that's most of them. There's a few sort of general observations in here. We had, what was this one? We had a tenant with a fish tank, which we thought was fine until the water pump went wrong and flooded the floor, and we only found out when it was leaking into the shop below. I suppose you can't.
Well, I mean, I was facetious and said goldfish would be fine, but obviously that's got nothing to do with the pet. That's got to do with I mean, you could equally well say that a tenant had a candle. Tenants with candles are fine until they forget about them, go out and set fire to your house.
Yeah, yeah,
It's not the pet. It's not looking after the installation properly.
that's right.
So I think that the point here is that, and this is the problem that I keep seeing with pets. People keep talking about pets from the point of view of the landlord or something that's got nothing to do with the pet. It's about the pet and the property.
Yeah,
I just want to ask one question was asked, which I thought was quite interesting, is someone saying people who support students rather than tenants, what were the key takeaways for students of this act? I mean, the key takeaway for students, obviously, is that they need to be very cautious about the type of accommodation they are in. If it is outside the remit of the Renters' Rights Act and outside the remit of the Housing Act 88, it will be fixed term accommodation, which means they will not have to give notice. If it is within the remit of the Renters' Rights Act or the Housing Act 88, they will have to give 2 months' notice to leave, and that notice will have to expire at the end of a period. And I would imagine that if student tenants don't give proper notice, landlords are very likely to start making deductions from their deposits to bring them back onto the correct notice period, and they will be perfectly entitled to do so. So I think one of the things that's really a problem for student tenants actually is that they're going to start out, a lot of them, in communication, sorry, in accommodation that is run by a university for a fixed term, and then shift out into accommodation that's run in a totally different way with different notice structures, and they won't know that, and they won't be aware of it, and they won't appreciate that they have to do it.
yeah.
I see this from a student perspective as one of the most damaging parts of this legislation.
Yeah. Okay, well, I mean, I think we're sort of at the end of the questions. I mean, there's still more on there, but there's we're coming up to an hour now, so I think we probably have to roll it towards the end now. There's been a few people asking about whether or not they'll we've recorded this and can we send it out. So yes, we will. Anybody that's on the webinar now, we'll send you a link to a recording, and we'll put this out on YouTube. So no need to take notes or what have you. The final thing is from me, really. So it's a little bit about us. So we are in a rather unusual and pretty fortunate situation that we are what's known as, I mean, I'll let David sort of tell you the legal sides of this or say where I'm going wrong. But essentially, we're what's known as a specified institution. So under the Housing Act, and we have been for about 13, 14 years now. What that means in practice is that we are treated in the same way as a university is, and it's probably, and it's something that was given to us by government years and years ago because we're linked to the two universities. And so what this means is that we issue non-assured tenancies, and we have done for years and years and years, in a similar way to the university will. And so what that means is this will carry on, and we'll be in the same position as universities are. We'll be in the same position as the PBSA is, which is obviously quite handy. Before everybody thinks that we're going to be expanding all across the universe, we're not. We operate in Leicester, but if you're in Leicester, I like to think that we've got quite a handy advantage there. And we're certainly going to talk to some of the universities, I think, about this, but we're not planning. It wouldn't be the nature of the organisation that we could be operating everywhere, but I think it's quite a handy thing. I think I've just said all that right, David. Does that make sense?
Yeah, that's correct. Yeah.
So there you are. That's quite a big bombshell, I think, at the end. But there you are. So we will send this out to people on the webinar list, as I say. We'll put it on YouTube as well. The final thing from me is, so there's the contact me and contact David. If you've got some very specific advice, obviously, he's the man to go to, not to me. And with that, I just thank you all for joining today. And thank you to David, and hope to see you all again soon.